Thank you.
Thank you, Satya. So, a little about this day before I invite my Senior Regional Director, Sir Dr. Amit Chaturvedi, to introduce our resource person. Just a brief about this program, about this day. Uh, this World Intellectual Property Day, as such, it was to be celebrated on 26th of April because every year it is celebrated on 26th April. But we had the instructions to commemorate or celebrate this day on 28th of April. So we have come together today for celebrating this day. And this day is basically celebrated every year to create awareness about the intellectual properties, the role that they play in fostering creativity and innovation. And today our person, Professor Satya Sethy sir, although now you are one of the renowned academicians in one of the premier institutions in India, IIT Madras, but you have been our own family member, a member of IGNOU fraternity. So you are a special person to us as a resource person, and we are fortunate to have got this opportunity to listen to you on a very important topic on this intellectual property right, academic integrity, and novel practices. With this, may I request, and let me tell that I myself and my Senior Regional Director, Sir Dr. Amit Chaturvedi, Additional Director, Sir Dr. A.M. Saklani, and my colleagues from Regional Centre Noida, we all join together to welcome you to this meeting. Now may I request our Regional Director, sir, to kindly introduce our resource person to the participants. Please.
Thank you, Dr. Anjana. Wonderful day. Today we are celebrating World Intellectual Property Day 2025. We have invited, I welcome Professor Satya Sundar Sethy to deliver a lecture on the intellectual property rights, academic integrity, and noble practices on World Intellectual Property Day 2025 webinar. We have invited for the deliver a lecture on the webinar. Professor Satya Murthy Sethy is a professor at the Department of Humanities and Social Sciences, Indian Institute of Technology, Madras, Chennai, India. He has been awarded Fulbright Fellowship Scholar in Resident 2022-2023 by United States India Education Foundation, New Delhi. Young Philosopher 2017 by the Ministry of Education, Government of India, New Delhi. During his Fulbright Fellowship, he was invited to give the lecture talk at the University of the Mississippi, Oxford, Utah State University, and the San Jose State University, California, University of San Francisco, California, Texas, A&M University, Texas, and USA, among the others. Professor Sethy has served in Indira Gandhi National Open University as assistant professor in Staff Training and Research Institute of Distance Education, STRIDE, New Delhi. He has published several papers in prestigious journals and contributed chapters to the edited books. His publication includes the books in Introduction of the Logic and Logical Discourse 2021, Higher Education and Professional Ethics, Role and Responsibility of the Teachers, edited book, and 2018, Assessment in the Learner Performance with Misra S. 2018, Meaning of and Language 2016, and Contemporary Ethics Issues of the Engineering, edited 2015, and Indian Philosophy 2010. His current research interests are assessment and evaluation in higher education, applied ethics, academic ethics, engineering ethics, and academic freedom, institution autonomy, and curriculum design and instruction design, engineering education and consciousness studies, and Indian philosophy. I welcome Professor Sethy to deliver a lecture on this wonderful day. And the topic is the intellectual property right, academic integrity, and noble practices. I also thanks Dr. Anjana as the Deputy Director, and Dr. A.M. Saklani, my colleague Dr. A.M. Saklani, Additional Director of IGNOU Regional Center in Noida, and my other colleagues, Mr. Kushwaha, and other faculty members of the Indira Gandhi National Open University who is participating in this webinar and listen about this wonderful topic, intellectual property rights and academic integrity in the noble practices. Thank you very much, Dr. Anjana, and I welcome Dr. Sethy to deliver lecture. Thank you very much, Sethy sir.
Okay. Thank you. So at the outset, I would thank Professor Uma Kanjilal, Vice Chancellor, then RSD Director Manorama Singh, followed by our Professor Amit Chaturvedi, who introduced me. Thank you for your kind words and a lot of descriptions about my academic work. Then, of course, Anjana, who invited me, and we met somewhere in Nepal some time back uh, on a conference along with the Srijan, along with Siran Mukherjee, isn't it? Okay. So with this, I would say that I feel very good and happy that now I'll be sharing my ideas and thoughts with IGNOU colleagues. And long back, I was in Stride, and it was an opportunity for me to meet a lot of peoples in a day-to-day basis, whether it is self-learning material preparation or giving counseling or so and so, and meeting regional directors, additional regional director in different centers. That's a very pleasurable moment. Even some time back, I shared with Anjana, look, I was staying in campus, and November, December, that flowers in the Maidan Gadi becomes memorable for us, and all of us were celebrating Holi and so forth in those days. So when I got this invitation from Anjana, I felt nostalgic because it's like homecoming, and sitting with colleagues to whom I wanted to sit for a long time and chit chat, so on and so forth. So with this, I welcome you all for this topic, and colleagues from IGNOU fraternity, ladies and gentlemen. The title of the topic, as both Dr. Anjana and Professor Amit shared with you, it is all about intellectual property rights, and it is related to all of us, whether you work in a regional center, study center, or headquarter, as a faculty, as a staff, hardly it matters. The reason behind that, it is not exclusively about those who are writing in the academic world, like research paper. It is about each and everyone, those who have a creativity, those who are producing something by using their creative mind and rational mind. So this is all about IPR, and I'm going to share my PPT here so that we'll be able to discuss things in details. I guess all of you can see the slides, isn't it?
Yes, we can see.
Just a second. So this is the title that I've given, keeping in mind that that we'll also discuss some of the things that you may be facing in your day-to-day life while dealing with SLM, self-learning materials, while dealing with faculty member, those who are contributing units and blocks for your programs. So therefore, we are going to celebrate today in a sense that we'll discuss, debate, and learn, argue, disagree, agree, whatever it may be. But this is all about the topics, academic integrity. What are the ways we should retain our integrity when we are working in an academic world? Whether purely academic as a researcher or a teacher or an administrator who takes care of both research as well as teaching, as well as counseling, tutoring, so and so. What are the noble practices people are doing across the globe? These things we are going to discuss today. So there are types of rights. Most of you may be knowing that. We'll go from known to unknown. So therefore, at the end, I believe that we'll have good question and answer session. The first and foremost right, all of us, we get it when we born on this earth, is called natural rights. What are the natural rights? The nature has given to us, like breathing. Nobody can stop our breathing. The time when we stop our breathing, it means we'll share our death. So breathing is a natural rights. Thinking, anything that you think, whether it is logical or illogical or anything for that matter, you think, nobody can stop thinking. Nobody can even force you that you can stop thinking. Rather, I would say, whenever you have a time, just shut your eyelids, all of you. Just think for a moment that right now you decided not to think anything. And trust me, nobody can afford to live in a time where you have nothing to think. So whenever you start nothing to think, there is something coming to your mind, and therefore thinking becomes a natural right. Similarly, imagining, hallucinating, lot of things coming under. These are our rights. It's called natural rights. We born on this earth, therefore we get the rights. The second one is about civil rights. Since we are the citizen of a particular country, we have to abide certain rules, regulations, we have to perform our duties. And therefore, we get certain rights. And therefore, we say these rights are called civil rights. Suppose you are in Myanmar, in other country, you may not get the rights, the civil rights, the way we are getting while living in India. So therefore, every country has a different way of explaining the civil rights, and depending on what political parties and so on, government, how they are doing it. So in our case, in case of India, we have a freedom of expression, freedom to earn livelihood, all sorts of things that comes under civil rights. Now, if you ask me the questions, does freedom of expression means anything and everything we can say? Can we able to accuse somebody? Can we able to use abusive language to others? I would say no. These are not part of the freedom of expressions. Whenever we get a freedom, there is a limitation, there is a boundary, there is a scope. And therefore we say everybody as a citizen of a country, we should know our limitation, our scope. Whenever we are using our freedom, that comes under civil rights. So some of us, we also use civil rights same as human rights, but human rights is one element of the set called civil rights. Now the next sort of rights called academic rights that applies to all of us. Whether you are working in IGNOU as an open and distance learning university or you are working in face-to-face university, hardly it matters. So long as you are academician, you are working in an academic institution, these rights, you would avail it. So therefore, students, teachers, staff, all of them, so long as they are in an institution, whether in university, college, or say engineering institution or any medical institution, anything for that matter, they say they avail the academic rights. So what it means, students get academic rights to ask the questions to the faculty members if they do not understand some concept. Students get the right to choose their optional courses. We have a right to disagree with some of the researchers. We have a right to agree with some of the researchers' ideas. We have a right to criticize someone's research findings. These are part of academic rights. But the time when we are retired, we do not get this academic right. The time when a student gets a degree, he or she doesn't get the academic rights until he joins another institution. Now, these are the rights broadly we have understood. Now we are entering into the specific rights called intellectual property rights. We, the human beings, sometimes we do not know the purpose of life. But if we clearly look into this matter, perhaps we'll find that God or Almighty or omniscient person, or you say somebody which is a supernatural force, has created us on this earth. And while creating us on this earth, has given certain kind of rationality, certain kind of intellectual power, and because of that, we think many things. And in some occasion, we come out with a new idea, new thought. That's called creativity. And since it is our thought, we want that this thought should be recognized by others. This thought should not be copied by others and should not be claimed by others as their own. And in that context, now there are many organizations, World Intellectual Property Organization, World Trade Organization, and many organizations. In 2000, they decided that let us celebrate the human being's ability that other creatures do not have. That's known as intellectual property. So since we have a creative mind, we think something new, we decide something new, we work on something new, and therefore we should have rights. That's called intellectual property right. Anything that comes out through the exercise of our intellect, through the exercise of our reasoning, through as a new product, as a new idea, we should be owning that. And in that context, they say human beings are the special creature on this earth because intellectual property rights are applicable only and only to human beings, nobody else on this earth. Now, intellectual property, whenever we are discussing about intellectual property, there are two issues usually come up. The first one is psychological creativity, and the second one is historical creativity. Many of us, we might have experienced, or if you relate to your experience, you will see. Sometimes, while reading something, you get an idea. While listening something, you get an idea. You feel joy about it. You feel happy about it because you think that this is a new idea. Perhaps nobody knows about it. The time when you enter into the literature, when you study many more things, when you listen many things from many sources, you will find that, oh no, that was the new idea for that time. But all these things already been discussed in many literature or people already knew about it. So therefore, when you as an individual, you think that an idea you get it, that you have not studied anywhere, that you have not learned anywhere, that you have not heard anywhere, and that is the time when you think that's a new idea for you, and later you know that, oh, that's not a new idea. It's already been discussed by many people in different literature. That's called psychological creativity. Now, how is it different from historical creativity? In case of an historical creativity, somehow you got a new idea, a new innovative idea. And after reading many literature, after discussing with many peers, you found that nobody has discussed about that idea. In that case, you say that's a historical creativity. Now, intellectual property, if you consider it a set, psychological creativity and historical creativity, any ideas, any arguments, any thoughts, any innovations, any discovery, these are the elements comes under the intellectual property rights. Now you say this intellectual property right is a big circle. Then within that, you have a psychological creativity and historical creativity. So in this way, we would say that human beings, we possess lot of ideas. We communicate lot of ideas. We use our ideas to bring new innovations, to resolve many social problems, to engineering problems, technological problems, lot of issues, social issues. But all these ideas may not be new. Only when we say that some ideas are new, some ideas are creative, and then we say we must own that idea, and therefore we say that is part of intellectual property rights. Now what it says, it legally allows, once you come out with a new idea that's not been there earlier, and you say it allows the creator is you, to reproduce it as many times as possible, because you own it. It can be translated, it can be adopted by many places. You can, some kind of music or say singing, you can have perform that, you authorize and receive money for that if you sell in the market. Sometimes you must be knowing that some of the IGNOU books may be translated into different language. That means those who have creator for that, that's a copyright. Those who have creator for that, they would be getting the credit out for it. Many of you might have written many books, and that book might have published in good publishing house. Now when that book is getting popular, second edition, third edition, fourth edition, many other country people, those who are comfortable in their own language, they want to translate it. Even though they translate it, they will seek your permission, because you own that idea, you own that argument. And therefore, we have come into this concept called, we have learned into the concept called copyright. So those who are aware of intellectual property rights, certainly they are aware of copyrights. Copyright means the right is exclusively given to the owner who has created that idea. So what it means, that person can sell it in the market, that person can translate it, that person can change it, that person can edit it. In that way we can say that everybody, those who are working in the academic world in any capacity, he or she must have copyright for his or her idea, and that should not be stolen, that should not be I would say should not be taken up from him or her and claimed by others as their own. That's violation of copyrights. In that context, you have a World Intellectual Property Organization, then you will have World Trade Organization. All of them together, they come out, they say, look, copyright means the legal rights that results from an intellectual activity, either with regard to industry, scientific, literary, artistic, any field for that matter. So in this way, we can say that intellectual property rights plays a very, very vital role in all of our lives. It's our day-to-day affairs. So suppose you ask a professors from other university or colleges or institutions to contribute say unit for a particular block. At the end, you found out that lot of violation of copyrights. That professor has written some statements, some passages, some arguments that are already mentioned in somewhere else, but this professor has not given the cross references. So what you do, politely you say that this is not your work. So therefore, since IGNOU sends its books to a lot of students within India and outside India, we must check these things, and therefore we are requesting you to make sure that you write the references properly, so that we should not violate the copyright issue. Somebody should not take us to the court as a legal cases. And in that context, we find the Berne Convention Amendment Act, that's 1988, it started. Because a lot of people are claiming one idea belongs to them only, but they knew that they have borrowed that idea from somewhere else. In that context, a lot of countries coming together, and they said that let us have intellectual property rights, some sort of agreement we should say that, so that there won't be any legal issues arise, that one person can steal others' work and say that it belongs to him or her. And in that sense, in those days, 164 countries, and right now it's around 183 countries coming together, and they said that that's a legal violation. And those who are publishing journal papers in different journals, you would be knowing that intellectual property rights nowadays, most of the good publishers, they're taking it very, very seriously. Now, what are the issues that arise? when we talk about academic integrity and intellectual property rights? Mostly plagiarism. Most of you know there are softwares available where people can write a lot of units even within 5 minutes, 10 minutes. And the same time, you also know what are the what are the software you need to use to check whether it is a plagiarized materials or not. Then there is a copyright violation. Now remember, there is a relation between copyright violation and plagiarism. I'll give an example, then I will explain it. Suppose, consider a case. You have a flat in Delhi, Noida, some sector. Now I will sell that flat to someone else, to the third member or the third party, without informing you, without seeking consent from you. The time when you realize that your flat is sold by someone else who is not related to you, and it is already money has been transacted between the two people without your knowledge, you will decide to drag these things to the legal court because they are snatching your rights. In the same time, there's a money transaction happened between the two people about whom you do not know. And this is exactly the same thing, the relation between copyright and plagiarism. Suppose somebody owns certain kind of arguments, certain kind of idea, certain kind of findings. That's an output of his or her creativity. So he or she owns that arguments or ideas or the findings. But at the same time, if the second person steals that, saying that this idea belongs to me and sells in the market and get a price. So what that first person will do? First person will drag both these people to the court and saying that, look how they have done misconduct by taking my work and claiming their own and selling in the market. So therefore, you will find that the relation between the concept of plagiarism and the violation of copyright with regard to any academic output, whether it is writing a book, an idea, or say in artistic like singing, or say composing a music, and so on and so forth. Now, fabrication and falsification of data. Now, those who have an impeccable life, having an integrity in their life, leading a purified life in the academic world, perhaps they will think twice, thrice, fourth time that whether to go about fabricating and falsifying data or not. Because nowadays, if you consider publish or perish, then many of us will attempt to publish it by somehow or other. And that attitude, that temptation sometimes misguide us to do this fabrication of the data and falsification of data. So what's going to happen here? If you falsify the data and if you fabricate the data and you publish somewhere, you never know who is going to read that paper from which part of the globe. The next time when they knew that this data is not a correct data, they will not just ban you to submit any papers in that publishing journals or publishing house. Rather, most of the publishing house, they have an union, which I'll tell you in few minutes time. They will never allow you to submit your work and publish it in any of their publishing house. At the same time, they'll publish that how you have fabricated the data, and therefore the whole world is not going to trust you, is not going to believe your findings, what you have mentioned in your research work. So therefore, it's like so much shame we'll bring to our life, and therefore we should be very, very careful about fabrication and falsification of data. Then non-publication of data. Many of us might have observed that some of the academicians, either through ignorance or through intention, they will suppress the data for a long years. And after 4 or 5 years, as you know that no data remains valid because things are changing, nothing is permanent, they try to publish it. For some of the regions, they think that right now they are busy, so 4 or 5 years they can preserve the data and later they can publish. And if they publish, that data is not a valid data. So non-publication of data, preserving for some time and claiming that this is an updated data, that's also violation of intellectual property rights. For example, in 2021, you collected some samples through questionnaire. You collected some data through questionnaire. And 2026, you are claiming that this data you collected in 2026 and you are publishing, that's violate the intellectual property rights, and thereby it questions your academic integrity. Now, faulty data gathering procedures. Some of you, since you are supervising PhD students, or you know what is to be expected in a write-up, so and so, through your experience, you will find out that some of these people, they try to, publish papers, try to write something on their own. They may think that that's a correct data, but if you closely examine their data analysis and interpretation, you will find that even though they went to a place to gather the data, but they did not gather the data properly. And therefore, the data they were putting in to write a paper to convey their ideas or to summarize the findings are violating the intellectual property right. Similarly, poor data storage and retention. Now consider a situation, somebody went to a village for a data collection for some other regions or a suburban area, and the data collected through a tool or a device that did not work properly, and therefore the question that you asked and the response you got it in an, say, open-ended questions, you are not sure what they said, what you asked, and therefore that every possibility you will be writing the data through the misrepresentations, and therefore that's violate the intellectual property right. Sneaky publication practices, like many people, they change the abstract and title, but the content remains same. And one paper they publish in some journal, and after changing the title and the abstract few words, the content remains same, the body remains same, and they publish in some other journal. And therefore they claim they have two publications having the same content, same idea, same thing. If this is the practice, then we say that's violate the intellectual property rights, and therefore it questions the academician's integrity about publishing. Misleading authorship, that's an interesting topic for all of us to understand. When can we claim our authorship? That I'm going to discuss in a few minutes time, but as I told you that about the publishers, that if somebody has violated the copyright and published something, plagiarized materials, and later people found out that by reading from different part of the world, then a lot of publishers, they come together and they ban that academics to publish any of his or her work in future. And here you will find Committee on Publication Ethics. Now, any journal, a good journal that comes to your mind, you check it, author's guidelines. If you scroll down, you will find that every good journal that abides the Committee on Publication Ethics norms, terms, principles, and guidelines. What it says, that if anybody's paper found that he or she has misrepresented, he or she has manipulated the data, it's not that paper only that can be taken out from the journal. Other papers can be examined and other papers can be taken out. And recently it happens near to your place, Noida. I'm not naming any person. That professor is a science professor who was editor of some of the journals and claimed that he or she was having nearly 50, 70 papers in, say, 4 or 5 years' time. Then later it was found that it was all sneaky publication practices. And now, after announcing these details, it is not just saying that that professor is not having any academic integrity, rather said that that profession violates the intellectual property rights. So that professor is not allowed to publish in any of these good journals. You can see those are part of this Committee on Publication Ethics, like Elsevier, Blackwell, Springer, then Taylor Francis, that's called Routledge, then Macmillan, then Culver, IGI Global, and so on and so forth. So those who are having little leisure time or free time, you can look into the website of Committee on Publication Ethics. So a lot of guidelines they provide. So who are the people involved here? Almost every country people, almost every professors, almost every higher educational institutions, almost every academicians, those who believe in teaching, research, and somewhere directly or indirectly related to the academics, they are part of this Committee on Publication Ethics. And once in 2 years, most of the people are invited from different part of the globe and they sit together, they decide a lot of cases, and then they come out with a new principle, new guidelines, and that has been followed by almost all the journals, almost all the publishing house, those who publish books, so and so forth. So I'm sure, since some of you are part of this IGNOU Regional Centers, you will be also contributing some of the units to some of this blocks for a new program of IGNOU and so on and so forth. Some of you also independently become an editor of a journal or editor of a book and so on and so forth. So this Committee on Publication Ethics is something important that all of us should know while celebrating Intellectual Property Rights Day. Now coming to authorship, nowadays almost every one of you know that through your experience, expertise, that authorship is a very challenging concept in today times, where you need to fill up, that's called academic performance indicator, API or something like that, and everybody wants to fill that form appropriately to get a promotion and so on and so forth. So what it suggests, it says that either publish or perish. If you cannot able to publish, you do not expect any promotion, so on and so forth. So therefore they say most of the people, they think differently how to publish a paper and what are the ways they can do it. So in that context, a lot of journal papers, they have mentioned that a lot of academicians are getting involved into say wrong practices, unethical practices for authorship. So what are these authorships mostly? It's a gift authorship. For example, I would say when I celebrate my birthday, you give me a gift. When you celebrate your birthday, I'll give a gift. So what it means? Suppose you, me, and all of us together we are working on a particular research field. So when you write a paper, you put my name. So I may not be knowing what is the content of the paper. I may not be knowing what is the argument of the paper. I may not be knowing what are the research questions or hypotheses of the paper. But somehow you give me a gift by writing my name in the paper, and that's published. Similarly, when I will write, I'll also return the favor to you, and therefore I'll write your name. And that time you may not be knowing the research question, hypothesis, objectives, tools, methods, findings of my paper. And now you see, without knowing the content of the paper, without owning the argument of the paper, still you become an author of paper. And in that sense, we say that's a gift authorship which violates the intellectual property rights. Is there any question so far?
I don't see anything, sir. You may kindly proceed.
Okay. The next one is called honorary. Honorary authorship is also a kind of misleading authorship. What is honorary authorship? And in case of honorary authorship, suppose you are working in a particular laboratory. So to make your boss happy, you give the name of your boss when you develop a paper, and that's get published. Your boss may not be knowing what's there in the content of the paper. Similarly, in most of the units, most of the centers, most of the schools, what happens? People give their deans, HOD names as an author, so that dean and HOD can help academicians to get a promotion or avail other academic opportunities. So that's a misleading authorship. Then ghost authorship. Ghost authorship is a kind of concept where you know that somebody who has earned the name and fame in a particular research area. And you know that if you put that person's name in your paper, you may get many cross citations, or there is every possibility that your paper may be getting published. And many people will consider that your stature in that research field will be very high, because somebody who has earned the name and fame already worked with you, and that's called ghost authorship. And later, when people will examine it, people will find out that you are the liar. You mention an author's name. That author even doesn't know who you are, what is that area that you work on, where you work on. And if that is the case, then we say that's violate the intellectual property rights. So therefore, somewhere I published one paper. Whenever you have a leisure time, you can go, who could be an author of a research paper? Then here I said, there are a lot of contributions in different headings people can make it if it's a collaborative research, like significant contribution in writing, significant contribution in revising, designing the research paper, data acquisition, data analysis, interpretation, statistical. Anybody who contributes in 2 areas can be the author of a paper. Else, he or she deserves an acknowledgement, not beyond that. And here already I discussed that what are the ways we need to find out whether students have clarity on plagiarism as well as on copyright issues. Many times students think copyright and plagiarism are one and the same, but that's not true. So here it is the right time for all of you, those who are working in a study center, evaluating students' assignments, so on and so forth, you should know that if an assignment that you get it, where there are tables, graphics, pictures, but there is no cross-reference to that, that means that student has owned that graph, designed that graph. But if it's not the case, it is our duty to tell them that it is a violation of copyrights. And same thing, here I would say that there are many software people use like Turnitin, so that you can find out what is the percentage of plagiarism that has been made, what is when it is submitted to the author, to the academicians for their evaluation. There is a new software, some of you may be aware of it, called Urkund. Urkund is a software that is enabled with our email. So what it means, when students submits either through SLM portal or through email, that's get filtered. And student may not be knowing exactly what is the percentage of plagiarism they have made it. But the report would be received by the teacher, and therefore it is the duty of the teacher and the responsibility of the teacher to tell the student that these are the passages, these are the statements are copied from somewhere else without mentioning their details, name and years, publication details. And therefore that's a plagiarism materials, and we discourage that because that's part of academic dishonesty. So in this context, we find there are 6 types of responsibilities that all the academicians we need to understand and we need to practice if we want to lead an impeccable life, if you want to lead a life that says that perfect academic integrity for our everyday work. So here I have also published somewhere called Journal of Academic Ethics, that's Springer Journal. So here I said, look, there are 6 types of responsibilities. The first one is called role responsibility. Since you are performing a role as a counselor or a tutor or an evaluator or a unit writer, if anything goes wrong, you will be directly responsible for that. So when you perform a role, you should know what are the intellectual property rights you need to understand and how you should take care of that. Similarly, causal responsibility. Causal responsibility, if something goes wrong in between the process when you are writing and until the print of a paper, if something goes wrong, then you should be able to predict much in advance and able to fix it. For example, if you see that some of the units are not printed properly because when the book is getting binding, that letters are coming very close and students cannot read it. In the process, some of the words of the letter, some of the letters of the word or some of the words from the expressions are getting cut when it's binding. Then it is your duty to say that that's not the proper binding. They need to reprint it properly so that it will benefit IGNOU as well as the students. Then capacity responsibility. You have a capacity to take care of students' needs, to take care of your colleagues, to take care of your research work, so and so. You cannot say that I have family responsibility, other responsibility, therefore I cannot able to do academic work. That's a violation of capacity responsibility. That means if you are a PhD, if you are holding an important position, people are expecting you to do something else in the given position, and if you say that I'm not able to do it, that's a violation of capacity responsibility. That means you have an ability and capacity to do that, but you could not do it or you could not achieve it. Liability responsibility is a legal responsibility. Mostly, I give an example in this way. In the classroom situation, if you say hurt some students by telling their caste and religion, that's a legal responsibility that people can drag you. So therefore, in the counseling session or something, you cannot afford to discriminate students based on their gender, religion, caste, and so on and so forth, or economic condition. That's a liability responsibility. Blame responsibility is something you say some people they have copied the whole block and sold it somewhere else. Then you can say that, look, I have read that books 2025, but those who have copied it, they might have taken this IGNOU material, say in 2000, which is very older one. Now here, it is a blame responsibility. Somebody said that, look, it is your duty to read this book of this edition, so and so forth. You can't say that you read that book from some other publisher, so and so forth. If the students do that, you say that's a blame that you put on them. But if the teacher or the counselors or the academicians, they don't tell clearly what the student is supposed to study for writing an assignment, then the blame comes back again to the academician. That's called blame responsibility. Last one is called virtue responsibility. Virtue responsibility is a responsibility where you will say a lot of people are involved to carry out a task. So therefore, everyone's responsibility becomes no one's responsibility. Now the best example I give in the class, like Bhopal, the tragedy, the gas tragedy that happens. So everyone's responsibility becomes no one's responsibility, and therefore, even today times, if you ask the Bhopal people what sort of traumatic experience they went through, they will be able to explain in their words. In this way, we should understand that since we are academicians, since we are leading an impeccable life in the academic world, we must be able to understand this responsibility and act accordingly. Now, this is all about copyright. Now, copyright was discussed by many people in many books, many journal papers, and they have also practiced. Now, when Open University came into the existence and distance learning was not there, they say open and distance learning. That means the resources should not be confined to only some people in the form of copyrights and so on and so on. How to disseminate knowledge? By sharing the information. Keeping that in mind, when a lot of Open University came into existence, a lot of students or learners, they join in the Open University. Some of the people, they come forward and they develop the new concept called copyleft. Copyleft means even though somebody has designed something, even though somebody has owned certain idea, he or she is not rigid about that idea. He or she is free to tell others that you take that idea, you may claim on your own. That's called open source. Here, you need not to give even reference to that person. So that's called copyleft. So Richard Stallman developed the general public license, a license where everybody can copy and paste it and so on. So everybody can take it and can claim on your own. And in this case, you may not find the ideas and arguments are written very comprehensively or lucidly and analytically. This is the difference between copyleft and copyright. In copyright, you will find the writing up, writer's write-up will not be published if it is not coherent, it's not analytic, not statistically strong or mathematically correct and so on and so forth. But in case of copyleft, some sort of lacunas are there. However, copyleft helps many of us to gather many knowledge informations from different sources by reading that. Now, there is a scholar called Linus, so who worked on PhD from Helsinki. So in the 2003, his work is all about how to generate the free license or the free content so that everybody can use it for their learning purpose. Learning should not be confined with only one person or two persons or three persons. So in that context, they said it's a free and open source software, a software that everybody can use, a content that everybody can use, and information that everybody can use. So what it says, necessarily it suggests that freedom to access the source code, freedom to use without paying license fee. Now remember, some of you may be using the PDF editor sometime back. That was freely available. But right now, it's the license. You have to purchase the PDF editor. Otherwise, the PDF document, you cannot edit it. Earlier, it was a free software, and now it is not a free software. Either it was a part of freeware, now it is copyright protected. So therefore, you need a password to open that PDF editor. In this way, a lot of things that you would be able to experience in our academic life. Now here also you need to you need to distribute it. You need not to feel bad, or you need not to seek the permission from the owner when you are going to distribute. So in case of freeware, you can freely distribute and you can freely modify. So in 2000, mostly between 2000 and 2002, but it started in 2000. But then that document came in 2002. The UNESCO started open source software movement is known as OER, Open Educational Resources. Most of this IGNOU people now will be talking about OER, Open Educational Resources. It started in 2000, but then when it was enacted, when the document came, it was in 2002. So open content materials follow the license policy known as Creative Commons License, CC. That's called CC. Because if everybody can modify every works and distribute it somewhere else and sell it in the market, so on and so forth, then people will not have a track who is doing what. And then lot of misrepresentation may happen, lot of miscommunication may happen. For example, sometime back you might have remembered some people were saying WhatsApp. When you get any information from WhatsApp, some people they get temptation to forward it to someone else without knowing the validity and truth of the information. And it's because of the free information one can pass on to somebody else, but you do not know the danger for that, the consequence of forwarding the wrong information to somebody else, and that may be modified further and sent to somebody else. And therefore freeware should be used properly by considering the Creative Commons license. And what is called Creative Commons license, that I'm going to discuss in 1 minute time. But here, as I told you, that freeware, some of you know Wiki Educator, Connections, Query, OER Commons. These are free software. Lot of materials are available there. One can read that, get the information, so on and so forth. So who can use this software? It's starting from kindergarten to lifelong learners. There is no restriction for that, but only when one should know what he or she is writing. Because reading the wrong sources may also help you to learn something wrong information. And therefore, the responsibility lies with that person who is using the materials from the freeware. Because he or she may not be able to know whether it is a peer-reviewed materials, whether it is a correct information, whether it is a true fact or not. In that sense, they say Creative Commons is an organization that helps to all of us academicians across the globe to share and use the creativity and knowledge through the free legal tools. This is a legal tool, but free for everybody. This is how exactly it happens. Some of you might be, when you are open the first page of the book, or when you see these chapters of a book, or when you read a paper in the journal, or when you see a movie or so on and so forth, you will find some sort of symbols like this. That's a Creative Commons license, part of intellectual property rights. So if you see this kind of symbol here, can you see my pointer? We need to give credit to that owner who has created that idea. But in case of this symbol, you can perform it, modify the works, and you need not to give this credit to that person who has created this work. Similarly, no derivatives. You can use it, but you are not allowed to modify it without prior permission of the owner. But the work can be copied, distributed, and displayed. Now can you see that, like a dollar sign, cross and round and something, that's called non-commercial. You can use it in your day-to-day life, that information, but you are not allowed to sell it in the market and get the profit of it. Now if you put permutation combination, some of the books are like this. You will find that these symbols. That means use the information and acknowledge who is the owner of it. Attribution, share alike. It's like Wikipedia. You can modify it. You can use it and share alike. Similarly, no derivatives. When you use it, you give the reference to that person. You give a cross citation to that person who is the owner, but you cannot, no derivative. You cannot afford to modify it at all. Similarly, the second one, if you see that, you cannot sell it in the market. If you do that, you say that open source, it is available. I am giving a reference, but I can sell it in the market. That's not allowed. If you do that, you are inviting the legal issues for that. Okay, over here in combination of the four symbols, it's like this. You can see that, give reference to that non-commercial. That means you cannot sell it. But here you can modify it a little bit. But at the end, the second one here you can say, you give credit, no modification, no commercial. And therefore, broadly you will find there are two sorts of license that usually people practice, whether it's a print material or say online material, or I would say that technological enabled materials readily available. So it's called no copyright. That means anybody can use for any purpose. It's available in public domain. Copyrights means whenever we use that materials, it is our duty and responsibility to give credit to that owner who has developed that idea. And this is the summary of mostly common creative license. Now you look at it here, it's called public domain. That means that materials anybody can take it and use for any purpose, can modify it. And here you can say, whenever you take the materials, you must give credit to that person. And accordingly, it is mentioned. Anybody who understands these graphs, understands how these materials, whether it is open source freeware, open source material is a freeware or copyright materials, both can be used in this way because that's a part of common creative license. Now here I would say, suppose you take a printout of something, but make sure that when you use that materials, what is that copyright is mentioned here? Is it this symbol, that symbol, or this symbol, that symbol? And accordingly, you can use it so that you can avoid the legal issues. Now, exactly the time that is given to me, 1 hour, I have used this. Thank you for your patience and listening to me. Now, happy to hear the questions.
Thank you very much, sir. Thank you for such an enlightening lecture on intellectual property rights. In fact, it has made many things clear to us because we have been hearing a lot about the intellectual property rights, but we actually could not find how these are applicable in our day-to-day life. Although I don't see any question in the chat box, I have a question. If we find that there is some infringement of our intellectual property right, I mean, whatever we have created, and we find that there is some infringement over that. So do we have any structure in the Indian system that we can claim that this is our intellectual property and it has been taken over by someone else? Do we have any such structure?
Yes, like we can write to UGC. UGC has a guideline, so we can write to AICT if it is an engineering institution, so and so, approved by AICT approved engineering program. They can write AICT. Then NCT, where Professor Panda was earlier chairman, so and so forth. Then a lot of, in case of IGNOU, again, it is an UGC. Earlier it was DEC, which is no more exists, as I understand. So now all of us can write it and write in such a manner that will be listed. That will be listed, and that person cannot afford to practice the same sort of plagiarism in future. That's a, I would say that it's a negation to the academic integrity. I would say this is a wrong practice, unethical practice, and some people rather drag this plagiarism to the court. Now you remember, suppose through your creative mind, you have written a book published by a brand publishing house that comes to your mind, and after 6 months you find that somebody exactly published the same thing in a different publishing house. First of all, it will not be possible. If at all it's the case, then since it is published like few years or 1 year or few months before, you can drag that person to the court and get a compensation, and that compensation is huge. And sometimes you might be seeing like two singers, they will be fighting for their copyrights. Two music composer, they will be fighting for copyrights. And if somebody has written a book and some film was shot on that, on the same theme, another film cannot be produced. There must be some changes. Otherwise, they have to pay a lot of crores in the legal battles. Thank you
very much, sir. Now may I request my senior colleague, Additional Director, Sir Dr. A.M. Saklani, for your remarks, sir.
We are thoroughly enriched by the presentation of Professor Sethy. The theme and the various issues and aspects related to it have been very nicely presented. He has traced the origin of rights and taken the context of intellectual property rights as the exclusive rights of a creator of these, and has thoroughly discussed the various issues in intellectual property rights and academic integrity, such as plagiarism, fabrication of data, Committee on Publication Ethics, the ethical responsibilities, copyleft, freeware, and Creative Commons licenses. The examples, I'm really overwhelmed. You have been part of the IGNOU family, and you have given us the valid examples for IGNOU contributors of units, evaluators, counselors, how they need to be very sensitive regarding the issues involved in IPR. In fact, the entire academic fraternity needs to be sensitive on these finer issues of while they are producing any research work, any publications, so that the academic integrity remains sacrosanct and the publication ethics have to be observed by all. Lastly, when Dr. Anjana raised her question, in fact, and the example Professor Sethy gave was for, and which is a very highly discussed issue in Indian cinema, song writers' rights on the copyright. And while we all know the way Lata Mangeshkar ji raised this issue and had a confrontation with the producers and others, and she was able to get those rights for the singers, in fact. So there is how the original question of creativity, how what is the role, what is the participation of a creator, and how would you assign that right to. So the fact that those copyright issues and royalty was finally, it came to the singers in Bollywood, was an important emergence of these rights, claiming these rights, and the fact that they are legally confirmed on research. We thank you so much, sir, for sparing your time, and we look forward to more talks and on various fora wherever it is possible. I thank our Senior Regional Director, Dr. Amit Chaturvedi ji, for giving us this opportunity, for inviting Sethy, my colleague Dr. Anjana ji for conducting this program, and the people from IGNOU headquarters, the regional centers, and the learners who have participated and listened to the talk. Thank you so very much.
Thank you so much, sir. Adisa would like to say something.
Thank you very much, Dr. Anjana, Dr. Saklani, and Dr. Professor Sethy. He gave a wonderful idea about the intellectual property rights and the day-to-day life, in the day-to-day life. Actually, we are watching the movies and after 10 years, there is a same name movie is coming. So is there any possibility from the law, they should not bring the name of the same movie after 10 years or 15 years? You know, in movies, and you know the songs, you know, there is a change in the lyrics, and they produce the songs. Is there any legal?
Yeah, like in an academic world, if we take 4 expressions together from a sentence, 4 expressions, 4 words or terms from a sentence, we have to give a citation, cross citation, because somebody has owned that. And in the same time, if we look at the music industry and film industry, so whenever there is a remix, songs are coming, they would be getting a permission from the composer or the music, I would say maybe producer or the music director who has the copyrights issue when the film was produced. So then there will be a money transaction that we are going to remix it, but certain content, certain rhythm, certain lyrics will keep it. Hence, there is a money transaction that happens, the negotiation, then there is an agreement signed, and then only remix can be allowed. Otherwise, remix will not be allowed. But naming exactly the film, they will have to purchase the copyright from the earlier producer, saying that, look, the theme we may little modify it, since we are taking exactly the name of your film which was popular earlier, so therefore we need that you should sign that copyright. An example, if somebody is going to produce a film called Soleil 1 or Soleil 2, or some spelling maybe SHOLLEY, something like that, But then, since the pronunciation, the phonetics, phatic and rhatic are mostly compatible with the earlier famous film, then the copyright who own that film, he or she must give in writing and can also ask a huge amount from that producer who wants to produce similar kind of film with a different change of the name of phonetics.
Thank you. Thank you, Dr. Professor Sethy. It is a wonderful interaction, and the large number of the students have participated in this webinar. And I also thanks to Dr. Anjana and Dr. Saklani and Mr. Satya, who conducted this program wonderfully. And I also thanks to Professor Satya Sundar Sethy ji for giving a wonderful idea about the intellectual property right in this program. Thank you very much.
Thank you, appreciate it.
Thank you very much, sir, for taking out time from your busy schedule. We understand that being in such a premier institution, you must be having short of time, and still you have derived time for us and accepted our request and delivered such an enriching lecture. We are so very much grateful to you. I'm personally grateful, and also on behalf of Regional Centre Noida, I place on record our sincere thanks to you for accepting our request. And this, we had invited a limited number of participants for this meeting due to certain security and moral concerns. But we have recorded this meeting and we will be uploading this lecture on our YouTube channel of Regional Centre Noida. So I'll make that link available to you also for your reference also. Before concluding this program, may I request Satya Pushpaji to kindly start the national anthem so that we may wind up this meeting.
मैं आप सभी लोगों से निवेदन करता हूं, कृपया अपने स्थान पे खड़े हो जाएं। अब राष्ट्रगान प्रस्तुत किया जा रहा है।
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे।
धन्यवाद।
The level goes to the